हाँ sir. Okay, a very good morning to one and all present here. I am Akriti Gupta, Faculty of Law and your host for the day. I would like to welcome all of you for the Constitutional Day celebration program with special regard to Professor O.R.S. Rao, Vice Chancellor of ICFA University, Jharkhand, Professor Arvind Kumar, Registrar of ICFA University, Jharkhand, and to all the faculty members and students and the dignitaries present with us today. First of all, I would like to convey my warm wishes I would like to convey my warm wishes with pride to celebrate this historic day on November 26, 1949. This reminds us of the history of India, India's independence movement, which led us to setting up of the Constituent Assembly to draft the Constitution of India. It was 71 years ago that we, the people of India, had adopted, enacted, and gave ourselves the Constitution of India, which was drafted after closely examining all the constitutions of the world. Drafting committee headed by B.R. Ambedkar framed a constitution which was appropriate for the nation with exceptional diversity seen through language, religion, race, caste, and class. So, moving towards today's program, I would request all of you to come together for the virtual lighting of the lamp.
ॐ असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतं गमय लोकाः समस्ताः सुखिनो भवन्तु। ॐ शान्तिः
Thank you, everyone. Now, I would like to call upon Professor O.R.S. Rao, Vice Chancellor of ICFA University, Jharkhand, for the welcome address.
Sri G.C. Shah, the retired District Judge, Jharkhand, Sri Pradeep Bhattacharya, Vice President, Dhanbad Bar Association, Sri Abhishek Anand, Additional Advocate General, Jharkhand, then Sri Abhishek Prasad, Secretary, District Legal Services Authority, Professor Arvind Kumar, Registrar, my dear faculty members, students, and among the faculty members, particularly like, in fact, Professor Alok Kumar and the entire law department, a very good morning to all of you, and my hearty welcome to today's Constitutional Law Day function. As Professor Akriti has mentioned, it was 71 years back that our Constitution was adopted by the Constituent Assembly of India. Dr. B.R. Ambedkar was the chairman of the council. It was 5 years back on the occasion of the 125th birth anniversary celebrations of Dr. Ambedkar, our Honorable Prime Minister Narendra Modi ji decided that the 26th November should be celebrated as the Constitutional Law Day in memory of Dr. Ambedkar, who was the architect of our Constitution. And today is the 6th celebration. Our Constitution has given us 3 important organs. It is legislature, executive, and judiciary. They are like the 3 important organs of a human body, like mind, heart, and the limbs. All of us, all of these organs must be in good health, so that as a person, somebody is very healthy. Not only each one of the organs must be healthy, all these organs must work in a coordinated fashion. It can't be that the mind, the brain works in one way and heart works in some other way. All of them have to be coordinated very well, so that the brain, heart, and the limbs and all of them work in a very coordinated and synergistic manner. And likewise, in the case of the Constitution is for India and for the Indian people. So that being the case, it is the responsibility of the people of India to keep these three organs in good health, and also to make sure that they are all very coordinated very well. We are so happy as the democracy, as the Indian democracy, like it is one of the oldest democracies today, even after 70 years of Constituent Assembly having approved the adopted the Constitution, our health, of our organic, the health of the Indian democracy is in pink health. And because the people, they owned the Constitution, and people and all these three organs, including despite the recent COVID-19 days into that, all these three organs have been playing a very responsive and responsible part. And in particular, the judiciary. Judiciary in the last few years, they have been very, very active. They are very responsive and responsible, and they have been playing even the watchdog, and they are making sure that all the constitutional kind of the rights that are there, they are all taken care of into that. As an education institution, like a University Jharkhand, on one hand, we have got the law department. We have been offering the various law programs like a BBA, LLB we are offering. We also have got the LLB program. And as an institution, it is the responsibility of our university to build awareness about democracy, about the Constitution, and the various provisions of the Constitution, not only to the students, but also to the society in general. And that's where, in the last few years, our law department and your university, they have been playing a very responsible part into that. I'm very, very happy, and I'm really proud of that. And so much so that, our law programs, the program syllabus has been worked out in such a way, it is one of the best syllabuses in the country. We looked at the national law universities and various other renowned universities, and then we have adopted the syllabus. And apart from that, all our students, they go through the moot court, and we also have got a legal service authority that is there. And we have been doing a lot of social service in and around our campus. I'm so glad that our law department, when they put this program together, they put together all those elements. There's a moot court competition for our students. Similarly, there's a parliamentary debate, because we have to mimic and see what is happening in the parliament. Likewise, what all messages we are giving, these messages have to be communicated very effectively, understanding the cultural aspects, and the environmental aspect. Keeping in this mind, our law department, found it, very useful to have a look at, so that they can convey all these things very effectively, not only to the students, but also to all the participants in this. So with these few words, I wish all of you a very, very happy Constitutional Law Day, and I wish the function all success. Thank you very much.
Thank you so much, sir, for your humble address. Now I would request all of you to stand and take the preamble pledge. Kindly repeat after me. Okay. We, the people of India, having solemnly...
We the
you
people
all
of
can
India.
put yourselves on mute and repeat after me, so that way it will be easy. Okay. We, the people of India, having solemnly...
We the people of India.
Having solemnly involved
democratic republic
We the people of India.
and to secure for all justice, social,
economic, social,
liberty of
Social
Justice,
belief,
social,
faith, and worship,
and
equality
of status,
and to promote
Akriti madam, please unmute yourself. Akriti ma'am, please unmute yourself.
Am I audible now?
Yes, ma'am. Yes, ma'am.
Okay. Okay, then let's start again. Okay, let's start with the pledge again. We, the people of India,
We, the people of India,
having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political,
justice, social, economic,
liberty of thought,
political,
expression,
liberty of
Social,
thought,
religion,
economic,
faith, and worship,
and
equality of
and
worship.
status
worship
and of opportunity, and
and
to promote
opportunity.
among them all fraternity,
All
assuring the
fraternity,
dignity of the
assuring
individual
the dignity
and the
of the
unity and
individual
integrity
and the
of the
unity
nation. In
of
our
the
Constituent
nation.
Assembly, this 26th day of November 1949,
26
do hereby
November.
adopt, enact,
To
and to
adopt,
give ourselves
enact
this Constitution.
this constitution.
Thank you, everyone.
Thank you, ma'am.
Thank you, ma'am.
Now, I would like to invite Advocate
Thank you, ma'am.
Ashutosh Anand Sir, who is the Additional Advocate General of Jharkhand, for the opening address.
A very good morning to this August gathering. I hope I am audible.
Morning, sir. Good morning.
Yes, sir.
Yes, sir. Yes.
Okay, so we have with us personalities from literally all the facets of law, eminent professors of the university, legal luminaries from the judiciary, myself representing the advocate fraternity, and the most important, the students of law. We all have gathered here because of the efforts put in by the ICFA University to celebrate the Constitutional Law Day. Being the opening speaker of the session, much can be said about what is a constitutional law day. Being a student of law, I would be more privileged to be a listener to the presentations being made by the students and the legal dignitaries on the dais. Still, as a speaker, it is my privilege to start this session with one of the famous quotes of Dr. B.R. Ambedkar, and I may just quote it. It is not that India did not know what is democracy. There was a time when India was studded with republics, and even where there were monarchies, they were either elected or limited. They were never absolute. It is not that India did not know parliaments or parliamentary procedure. A study of Buddhist Bhikshu Sanghas discloses that not only there were parliaments, but the Sanghas knew and observed all the rules of parliamentary procedure known to the modern times. They had rules regarding sitting arrangements, rules regarding motions, resolutions, quorum, whips, counting of words, voting by ballot, censure motions, regularization, res judicata, etc. Although these rules of parliamentary procedure were applied by Buddha to the meetings of the Sanghas, he must have borrowed them from the rules of the political assemblies functioning in the country in his time. This is the quote of Dr. B.R. Ambedkar, and it portrays his far-sighted vision, which subsequently laid to the foundation of the Indian Constitution. Friends, as we all know, that Constitutional Day is being celebrated since the year 2015, which earmarks the 125th birth anniversary of Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constituent Assembly. Many may not be aware, but earlier to this, we celebrated this particular 26th November as Law Day, and the same preamble oath, which we have just participated in, we used to do this since time immemorial after coming into force of the Constitution. In our college, we used to take and subscribe to this oath to spread the importance of the Constitution and thought and ideas of our own Dr. Ambedkar. As part and parcel of the supreme body, that is the Constitution of India, and to honor the drafter of the Indian Constitution and to celebrate it in a big way, various programs have since been held by various ministries and departments throughout the year. While laying down the foundation stone on Ambedkar Memorial in October 2015, our Honorable Prime Minister announced that 26th November will be celebrated as Constitution Day. In November 2015, the government official announced celebration of the day as such. Friends, unlike any other special day, Constitution Day is not a public holiday. It is a day not to pass your time, but a day to understand the values of the Indian Constitution. On this day since 2015, programs have been devised so that the Constitution and especially the preamble is read in schools by the students. In addition, there are quiz and essay competitions, both online and offline, on the subject, as also lectures on salient features of the Constitution. The Department of Higher Education has requested various universities to arrange for parliamentary debates in colleges, and the University Grants Commission has suggested for All India Quiz Competition also. Even in overseas, 26th November is celebrated as Constitution Day, and emphasis has been made to translate the Indian Constitution into the local language and distribute the local translated copies to the various academic libraries and faculty of Indology. In fact, friends, you would be glad to know that the translation of the Indian Constitution has been completed even in Arabic as well. Events including Run for Equality, as also a special session on Indian Parliament on 26 November 2015 is being held routinely to give tribute to the Constitution and Dr. Ambedkar, and this is a ritual. Since then, we have been following the practice of celebrating the Constitution Day with a number of activities, and the entire purpose of the activities is to inculcate the knowledge about the Indian Constitution and the ideologies of Dr. Ambedkar. Friends, I've been attending various seminars celebrating this day, and from my limited experience which I have, I've gathered that the universities celebrate this day as Constitutional Day. I was really delighted to find that ICFA University is celebrating this day as Constitutional Law Day. This is quite uncommon. Earlier, there was Law Day, and since 2015, we are celebrating it as Constitutional Day. Importance of the Constitutional Law Day, as rightly put by the ICFA University, is essential in as much as at present, just reading the Grund Norm, and we call the Constitution as the Grund Norm, never suffices the cause. We are to test the other applicable laws to the touchstone of the Grund Norm. We have seen the development of law, including the Constitution, and it has resulted in being called a living soul. Friends, all are learners in the field of law and take pride to say that we are the student of law, but at the same time, we are the persons bearing the torch and have to ensure that the society still remains a decent, civilized society. I was really glad to hear the opening remarks by Professor Akriti and the Vice Chancellor. As per the schedule which has been circulated, we have got Professor Arvind Kumar, Registrar, and other eminent personalities who will be carrying forward this momentum. The ICFA University is living up to its commitment of grooming professionals with values. I saw that there's an integral aspect called as moot court. And believe me, my friends, whatever I am today is because of the hardcore moot court activities which I had taken in my college days. Do it right from the first year, maybe as a researcher to a researcher. You'll learn a parliamentary debates is much essential in the present scenario to understand in the present legal system the need of new laws. Nukkad Natak. This is an age-old tradition which we have been focusing on to disseminate knowledge, and I really congratulate the university in continuing with the tradition. Friends, the Constitution of India has undergone a number of amendments, but its basic values have always remained the same. The Constitution declares us a socialist, secular, democratic, and sovereign republic that assures to its citizens equality, justice, and liberty, and promote the value of fraternity. The Constitution is the sole backbone of the country that keeps the entire country together with so many diverse cultures, languages, and ethics. Since its enactment and adoption, the significance of these values is that without this, the state would fall into the prey of anarchy, fascisms, and authoritarian regime. There is no alternative for the Constitution of India, and it is the ultimate lex supreme. Friends, the Constitution has turned an institution building process, and it has not come to a stop on 26 November 1949 after it was written. Even after its commencement on 26 Jan 1950, the Constitution of India was further made to go through its actual working, judicial interpretations, and constitutional amendments. The Constitution kept growing for betterment and acquired newer and newer meanings by the manner in which and the men by whom it was worked from time to time. The story still continues and will continue. Friends, as a student of law, it is our duty to ensure that the basic structure of the Constitution remains the same. There are a number of things which can be thought of, but at present, I would like to just conclude and express my thanks to the ICFA University, the professors, the students, and all the listeners present for giving me the present moment. I thank you once and again, once all. Thank you.
Thank you so much, Ashutosh sir, for your great insight on Constitutional Day. Next, I would like to call upon our team for the final round of moot court competition, and the panel of judge for this event would be Shri G.C. Sinha, advocate. Shri G.C. Sinha, who is a retired district judge, and Advocate Pradeep Bhattacharya, who is a vice president of Dhanbad Bar Association, who would be judging this moot court competition. I would request team 012 to plead on behalf of the appellant. Team, are you ready?
Yes, ma'am.
Yes, ma'am, we are ready.
Okay, go ahead.
Ma'am, am I audible?
Yes, you are audible, Josepha.
May I start? Ma'am, may I start?
Panelists, are you ready? Can the team start? Sir,
Hello.
Yes, sir, can they start?
GC Sinha और क्या
Yes. So should we start with the moot court competition? Pradeep Bhattacharya sir and GC Sinha sir. Okay, I think team 012, you can go ahead. The panelist is here.
Okay, ma'am. Thank you. With the prior permission of the bench, may the council intimate the time duration to the courtroom in charge. Much oblige your lordship. Your lordship, team 012, representing appellant, the speaker one would be taking 12 minutes and my co-counsel will further be taking 12 minutes. Much oblige your lordship. The honorable bench, to the honorable bench, this is the counsel appearing on behalf of appellant in the case of Vijay and others versus state. The counsel shall be dealing with issue number 2, issue number 1 and issue number 2, whereas the co-counsel will be dealing with issue number 3 and issue number 4. Much oblige your lordship. With the prior permission of the bench, may the counsel proceed with the state the jurisdiction of the case. Much oblige your lordship. The Honorable District and Session Court held the jurisdiction in the matter under Section 307 and 120B of Indian Penal Code, which are as follows. Vicky, Vijay, Sanjay, Sunny, and Krishna are liable for rigorous imprisonment of 10 years and a fine of ₹10,000 each under Section 307, which is attempt to murder. The court granted Vicky imprisonment of 6 years under Section 120B, which is criminal conspiracy to commit an offense punishable with death. Much oblige your lordship. Your lordship, if the bench is well versed with the fact of the case, may the counsel proceed with the formal argumentation of the case. Much obliged, Your Lordship. Your Lordship, counsel will be first dealing with issues, whereas firstly, counsel will deal with issue number 1, state the issue number 1, and after that, counsel will state the issue number 2. Much obliged, Your Lordship. Your Lordship, issue number 1 is whether section 374 of Code of Criminal Procedure is maintainable or not, as the appellant demands for appeal in the High Court against the conviction. Your Lordship, issue number 2 is whether money has been recovered from the possession of any person arrested. Much obliged, Your Lordship. Your Lordship, with the prior permission of the bench, may the counsel proceed with the formal argumentation regarding issue number 1. Your Lordship, it may please the bench to refer to page number 9 of mooting memorial. It may please the bench to pay attention on section 374 of Code of Criminal Procedure, which states appeal for conviction, which provides that any person convicted on trial held by a high court is in its extraordinary or original criminal jurisdiction may appeal to the Supreme Court. Any person convicted on trial held by the session judge or an additional session judge, or a trial held by any other court in which a sentence of imprisonment for more than 7 years has been placed against him or against any other person convicted at the same trial may appeal to the High Court. Much obliged, Your Lordship. Your Lordship, as in this case, as per the fact of this case, the Vijay, Sanjay, Sunny and Krishna are liable for rigorous imprisonment, and as directed by district court, they all accused are liable for imprisonment of 10 years. District and session court, the accused have appealed in the High Court against the conviction of district and session court. May please, I wish to open the case of Lakshman Das Kevalram Ahuja versus State of Bombay on 28th May 1952. The appellants, Your Lordship, the counsel will state a fact, the judgment of this case. The appellant were convicted and sentenced to death and varying terms of imprisonment by Special Judge Allahabad on charges of murder and other offences under Indian Penal Code, the Arms Act and the Bombay District Police Act on December 31st, 1949. They appealed, and then the government of Bombay directed that the trial of the appellant should be held by the special judge in the Allahabad Central Prison. Your Lordship, as the issue raised under section 374 of CRPC by district and session court, whereas the conviction is maintained, whereas the question raised that whether the conviction is maintainable or not under the section, so it is maintainable as none of the accused were involved directly or indirectly in the robbery. Your Lordship, as per the fact of the case, police did not arrested any of the accused from the place of occurrence, where no eyewitness was also were proved from the place of occurrence. Your Lordship, it may please the bench to refer to page number 9 regarding issue number 2, formal argumentation. May it please the bench to pay attention on section 165 of Code of Criminal Procedure, which provides search by police, which states that whether an officer in charge of police station or a police officer making an investigation for reasonable grounds for believing that anything necessary for the purpose of an investigation to any offense which he is authorized to investigate may be found in any place within the limits of police station of which he is in charge or to which he is attached, and that such thing cannot in his opinion in writing the grounds of his belief and specifying in such writing. Much obliged, your lordship. As per the section, as per the facts of the case, it is very clear that no sum of where it's very clear from the fact of the case, your lordship, no sum of money were being found from the position of Vijay, Sanjay, Sunny, Krishna, and Vicky. Your lordship, as per the fact and as per the fact of the case, it is important to be noted that even from the search of house of Sunny and Krishna, no money has been found from their possession. Your lordship, it's a kind of thing. If they have been involved in the robbery, the money would have been found from their possession. As per the fact of the case, your lordship, as we can see in the fact that as the police haven't recovered any sum of money from all the accused from the place of occurrence or from the possession of any of the accused, although no such evidence or proof have been found from the house of all the four accused, and your lordship, it nowhere proves that they have done any robbery or indirectly involved in the robbery, my lordship. We need to pay attention on section 390 of Indian Penal Code. Your lordship, as it states, robbery, in all the robbery where there is either theft or extortion, your lordship, when extortion is robbery if the offender at the time of committing the extortion in the presence of the person put in fear and commits the extortion by putting that person in fear of instant death or of the instant hurt or of instant wrongful restraint to that person or to some other person, and by so putting fear includes the person so put in fear that they're there to deliver up the things extorted. Your lordship, as from the fact of the case, it is very clear that police did not able to recover any. Didn't arrested any of the accused from the place of occurrence, and there were no witness found. Rather, one or two might be there, but no evidence were found of robbery from there. And as per the fact of the case, your lordship, no sum of money have been found from any of the accused. So your lordship, it shows that they were not present at the place of occurrence. Your lordship, may it please the bench to refer to page number 10, point number 3 of formal argumentation. Please, formal argumentation of issue number 2. Much obliged, your lordship. Your lordship, as per the investigation of police, as per the facts of the case, as per the investigation of the police, the photographs of the locality of the place of occurrence found in Krishna's house by the police search, and it nowhere proves Krishna's involvement in the robbery and can be so far possessed too. Furthermore, your lordship, mere findings of photographs in the Krishna's house do not prove that photos were kept by Krishna and could also be kept by someone else anyone else trying to falsely implicate him in this case. Your lordship, may it please the bench to allow my co-counsel to proceed with issue number 3 and issue number 4. It was honored arguing before the session. Much obliged, the lordship.
Morning to the bench. I am the co-counsel of this case. With the prior permission of the bench, may the counsel proceed with the issue number 3 and issue number 4. Much obliged, your lordship. Issue number 3 is whether the identification parade was conducted in the absence of any judicial magistrate. Issue number 4, whether the statement under section 161 of criminal procedure have been made by the approver before the court and whether the accused has been falsely convicted under section 307 and 120B of Indian Penal Code. Much obliged, Your Lordship. With the prior permission of the bench, may the counsel proceed with the formal argumentation of issue number 3. Much obliged, Your Lordship. May the bench pay attention on the page number 4 regarding issue, page number 10 regarding issue number 3. So paragraph number 4, the identification parade was conducted by the police authority in the absence of any independent person or any judicial magistrate. Your Lordship, it's very clear that only Krishna, Sunny, Vijay and Sanjay were participated in the identification parade. May I please the court to pay attention in section 162 of CRPC that provides that no statement by any person to the police in the course of investigation under this chapter. May Lordship, the shall, if reduced to writing the sign, the person making it, nor shall any statement of any record, therefore, at the identification parade cannot be given of such evidence on which order of conviction can be passed, but court can believe in substantive evidence of magistrate for doing identification parade. Much obliged, Your Lordship. With the prior permission of the bench, may it please the court to pay attention in page number 10 regarding issue number 4. Vicky became the police officer. As the fact of the case, the Vicky became the police approver. May it please the court to pay attention in section 161 of CRPC, that is, the examination of a witness by police. Any police officer making an investigation under this chapter or any police officer not belong to such rank as the state government may by general or special order prescribed in this behalf, acting on the request of such officer may examine orally any person supposed to acquaint it with the fact and circumstances of the case. Much obliged, Your Lordship. As given in the fact of the case, that the statement in front of police officer has not been statement of approver have made before the court, and may I please the court to pay attention on section 164 of CRPC, the recording of confession or statement should be before judicial magistrate. Section 164 in the Code of Criminal Procedure 1973 deals with the recording of confession and the statement. May I please the court to pay attention on page number 10 of a mooting memorial of regarding issue number 3, issue number 4, the paragraph 1. Any metropolitan magistrate or judicial magistrate may, whether or not he is judicial in the case, record any confession or statement made to him in the course of any investigation under this chapter, or under any other law of which be enforced, or any afterward being the confessment of the inquiry or trial. Provided that no confession shall be recovered by a police officer, it is very important to be noted that there is no recovered by a police officer on whom any power of magistrate has been conferred under any law for the time being enforced. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound to the confession, and that if he does so, it may be used as evidence against him. It is very important that any magistrate shall not record any such confession unless any question the person making it so reasonable believe it that been voluntarily. May I please the court bench to pay attention in page number 11 of mooting memorial that if any time before the confession is recorded, the person appearing the magistrate states that he is not willing to make the confession. The magistrate shall not authorize the detention of such police in the custody. Any such confession shall be recorded in the manner may I please the court to pay attention in section 281 of CRPC for recording the examination of an accused person and shall be signed by the person making the confession and explained to the name that he is not bound to make a confession and made that if he is not done so, any confession made it. It was taken in the presence and hearing and was read over the person making it and admitted by him to correct, and it contains a full and true account of statement made by him. My lordship, the fact of the case, any statement other than the confession made of subsection 1 shall be recorded in such manner hereinafter provided for the recording of evidence as in the opinion of magistrate best fitted to the circumstances of the case, and the magistrate shall have power to administer oath to the person whom statement is recorded. The magistrate reading confession or the statement under the session shall forward it to the magistrate on the basis on the whom the case is inquired into a trial. It is very important point here to be marked, your my lordship, on the basis of with the fact of the case on the basis of technical input given by Airtel, it was found that on 15th January 2019, that is on the date of occurrence, your lordship, the so-called robbery, both the mobiles of Vijay and Sanjay were detected in the local Airtel network in Delhi. Your lordship, so they were not present in the place of occurrence. That is, when the incidents, your lordship, when the incident happened in the Amritsar or someone else, someone else might be using their phones. That is of Vijay or Sanjay's phone, your lordship. Mobile phones become the later, the Airtel SIMs were found in the black Indica car 50 kilometers away from Amritsar at Amritsar-Jalandhar highway. Your lordship, on 16 January 2019, this is no way proof that the SIM were registered by the name of Sanjay and Vijay. It is very important that it was important that the SIM were not registered when the name of a Sanjay and Vijay was used by them. According to the, may I please the court to pay attention on section 11 of Evidence Act 1872 when fact not
Team
otherwise.
012. Team 012, I would like you to conclude because I think you've exceeded your time limit. Kindly conclude your pleading so that we can ask the panelists to ask you any question if they have.
Okay, ma'am. Okay, your lordship. Give me a second so that I can conclude my prayer. With the prior permission of the bench, may I state the prayer of the case in the above present in the prayer that is this honorable court may be pleased to set aside the order of court and allow this appeal to pass such order and further orders as may be deemed necessary on the fact in the circumstances of the case, to set aside the charge made under section 307 and 120B of IPC, for which an act of kindness the appellant shall, as in duty, bond ever prayer. This concludes my summation. Much obliged, your lordship.
Thank you, team 012. Now I would request the panelists to pose any question if they have. GC Sinha sir and Pradeep Bhattacharya sir, if you have any question for the team, you can please ask them. Yes, sir. You're audible. Sir, we are waiting for your question. If you have any question for the team 012, or should we proceed with the next team? I think there is some Okay, I think there is some network issue. So we'll move on to the next team. Our next team would be 011. The respondents team, are you ready to plead on behalf of the respondent? Team 011.
Ma'am, am I audible, ma'am?
Yes, yeah. Yes, Saurav, you're audible.
Yeah. Prosecutor seek permission from your lordship. Lordship, today we are here for looking. An appeal petition has been filed by the applicant, Mr. Sanjay, Vijay, Vicky, Sunny, and Krishna against the judgment of the Honorable Session Court. On behalf of my client, I counsel the defendant represent the current matter, that is Vijay and others versus State of Punjab, has been listed before the High Court of Punjab and Haryana under the gateway of Section 374, subclause 2 of the Criminal Procedure Code 1973. Your Lordship, the accused for the matter, Mr. Vicky, Vijay, Sanjay, Krishna, and Sunny, have been charged under Section 397, 307, and 120 capital B of the Indian Penal Code. Lordship, I, the speaker one of the team 011, want to argue on the framed issue, and that is whether the petition is maintainable or not. And the second issue is that whether the police approver is a credible witness or not. So I, the speaker one, will argue on the issues number 1 and 2, and the rest of the issue will deal by my speaker second, my co-counsel. And your Lordship, if the court already acquainted with the fact, may I proceed further? Much obliged, my lord. My lord, the counsel seek permission to kindly allow the screen sharing. As a result, it's gonna be easy for the court to represent the present case. Please grant permission, your Lordship.
Saurav, because there is some technical issue, you don't have to ask. You can just proceed with your thing.
Okay,
right?
ma'am. Is it visible, ma'am?
Hello.
Yes, Saurav, it is visible.
Yeah. Much obliged, my Lordship. Lordship, as you can see in the moot memorial, the first argument and the first issue, that is whether the petition is maintainable or not. It's the most humbling offense submitted this before Honorable Court, that the I'm referring that just miscarriage of justice and that exists miscarriage of justice was valid, and if the High Court overturned the decision, that I'm just victim, your Lordship. And the Lordship second to argue, and I want to refer that the statement of the police approval. For the same, I refer the section 118 of the Indian that shall be competent to testify unless the court consider that they are prevented from understanding
Saurav,
the question.
I think you should stop sharing your screen because there is some network issue and your voice is not coming properly. So your talking is more important here. So you can stop the screen sharing. Maybe your voice will be audible because of poor network, I guess. Saurav, you froze.
Yeah, is it okay, ma'am, right now?
Yes, now it's better. At least start talking.
Yeah, much obliged. Just again, I'm putting section 1 evidence that it is also that all persons shall be competent testify unless the court considered that they are prevented from understanding the question to put them or from giving rational answer to those questions by tender years, extreme old age, disease, with a body or any other cause of the same kind. Your Lordship, I'm referring the para 8 of the fact sheet that coherently stated that the police requested Vicky to make himself a police appropriate. In return, he will escape the punishment. It implies that the Vicky voluntarily become the police appropriate.
Uh, Saurav, your voice is not audible. Mansi, would you like to coordinate with him and see what is the problem?
Yes, ma'am.
We are extremely sorry for the inconvenience. There is some technical issue. I think we have to wait for 2-3 minutes for the team to get back. Yes, Mansi? Where is the first speaker?
Ma'am, he's over here. Saurav, continue.
Ma'am, is it okay?
Yes, Saurav, please continue and try to wrap it up.
Sorry for interruption, Your Lordship. I was on
Saurav, switch off your video and then try to talk. The network is really poor. You're not audible. Your voice is cracking. Switch off the video and try to talk.
Your Lordship. Lordship, I was in para 6 of the fact sheet that we conclude that Vicky was one of the accused or a compliance of the criminal act, and it is easy to rely upon the Vicky statement as the corroborative evidence is present in the case. Lordship, for the same, I want to attention of the court that in the section 133 of the Indian Evidence Act, along with 114B of the same act, that clears that the most vital things regarding the compliance evidence is corroboration. As I have ever stated that the case contains corroborative evidence, and for the same, I want to refer.
Saurav, unmute yourself. You have put yourself on mute. Team 011. Team 011, are you there? Anyone, the second speaker? Mansi, do we have you with us?
Yes, ma'am.
I think Saurav is having some network issues. You can take the argument forward and you can start with your prayer, right?
Ma'am, I'll continue with my prayer.
Yeah.
Okay, ma'am. Just a second.
Go ahead. You can continue the thing. Mansi, am I audible to you?
Yes, ma'am. Yes, ma'am. I'm sorry I was joined. Please continue with that.
You can proceed.
Okay. Okay, Saurav has joined.
Ma'am, may I continue?
Yes, Saurav, switch off your video and then try to continue, and if try to wrap it up in a short
Yeah.
span. Go ahead.
Your Lordship, for the same, I want to refer the Sarwan Singh versus State of Punjab. In the year 1957, Supreme Court clearly stated the double test for the same. And to establish a procedure to ascertain reliability of the approval testimony, the court needs to satisfy itself that the statement of the approver is worthy of credit. In addition to this, there must be some important evidence apart from the statement of the approver that is played a role in the crime. And the same scenario has happened in the case of the Mahadev Singh versus the King in the year 1936, in which the Privy Council decision is relevant in this regard, as the Blackstone say that the mere act of the charity which relieve or comfort a felon, but do not hinder his apprehension and conviction, nor aid his escape. For the same, I also want to refer one of the section for the same, for this act of section 9, that talks about that fact necessary to explain or introduce a fact in an issue or relevant fact, or we support or rebut an interference suggested by fact in issues or relevant fact, or which establish the identity of anything or person whose identity is relevant, or fix the time or place at which any act or issue relevant fact happened. For the same, I also refer the second case, that is Satya Narayan versus State, in which the test of identification parade was coined out that, and in this case there are two other tests has coined out. The test of identification parade has to satisfy two things. The first, you need to satisfy investigation authority, which is responsible for the entire investigation process, and that the person arrested were not previously known the witness. And the second, to satisfy the court that accused arrested in the fact in the culprit. With the reference to parrot 12 of the fact, we can conclude that the test of identification parade properly executed as per procedure established by the law that is given in the section 9 of the Indian Evidence Act 1878, along with their enormous higher court judgment that talks about the true procedure of the identification parade. So that's all from the speaker number 1, your Lordship, and the rest of the argument will instruct by the speaker second for the issues number 3. That's all. Much obliged, your Lordship.
Good morning, everyone. I'll be continuing with issue number 3, that is whether in fact the accused are liable under the section 307, 397, and 120B of the IPC. It is the case of section 397 of IPC. Section 397 of IPC defines robbery or dacoity with attempt to cause death or grievous hurt. If at the time of committing robbery or dacoity, the offender uses any deadly weapon or causes grievous hurt to any person, or attempts to cause death or grievous hurt to any person, the imprisonment with which such offender shall be punished shall not be less than 7 years. In the case of Muralidhar versus State, the Supreme Court declared and categorically that recovery of weapon is not a necessary ingredient for conviction under section 397 of IPC. The use of same to threaten is sufficient. The accused in the present case clearly used the knife. The same was within the vision of both the victims as per the testimony. They were terrorized and threatened due to the use of the same. The next is the case of section 307 of IPC. Section 307 of IPC clearly states attempt to murder. Whoever does any act with such intention or knowledge and under such circumstances that by the act caused death, he would be guilty of murder, shall be punished with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. In the case of Ram Babu versus the state of Maharashtra 2007, the Supreme Court stated and justified a condition under Section 307 IPC. It is not essential that fatal injury capable of causing death should have been caused, although the nature of injury actually caused may be of assistance in coming to a finding as the intention of the accused. This case of Section 120B of IPC. 120B of IPC defines punishment of criminal conspiracy. Whoever is a party to criminal conspiracy to commit any offense is punishable with death, imprisonment of life, or rigorous imprisonment. If your lordship doesn't have any further query, the council would like to proceed to prayer.
Mansi, before you proceed with your prayer, kindly switch on your video.
Yes, ma'am. Ma'am, am I audible?
Yes, you're audible, Mansi. Go ahead.
Yes, ma'am. Wherefore, in the light of the facts stated, issues raised and arguments advanced and authorities cited, the council on the behalf of appellant requests the court to adjudge and declare that Honorable Court is pleased to declare that the case is not maintainable. Honorable Court is requested to acknowledge that the police approver was a credible witness with regard to this case. Honorable Court is requested to punish all accused and uphold the decision of the Session Court and pass any order it may deem fit in the interest of justice, equity, and good conscience. All of which is most humbly and respectfully submitted. If your lordship doesn't have any further query, we would like to submit our oral submission over here. Thank you.
Thank you so much, Team 011. Now I would request the panelists to pose any question if they have for Team 011. PK Bhattacharya sir and GC Sinha sir. If you have any question for the team, you can please go ahead and ask your question. Sir, Sinha sir, do you have any question for the team?
No.
Okay. Okay, thank you so much, panelists. Now I would request the panelists to give some tips for the students regarding court proceeding and make them understand the value of the Constitution and address everyone present here. Sir GC Sinha sir, I would request you to give your closing remarks first. Sir, am I audible to you?
Yes.
Yes, sir, kindly address everyone with your closing remark.
Thank you for inviting me as a guest. इस पेंडेमिक में भी सब काम कर रहे हैं, बहुत अच्छा लगा. Both the parties are performed well. It's good to see the youth of the nation came up with such creative ideas. I look forward to attend such more moods, good research work. All the best for future.
Thank you so much, sir. Now I would request PK Bhattacharya sir to give his closing remarks and give the students some tips on the court proceedings.
Whether I am audible?
Yes, sir, you're audible.
First of all, I would like to say the table which has been given to us so far the moot court final evaluation sheet is concerned, there our teachers, law teachers and law professors have very nicely tabulated what are the ingredients of the moot court. In fact, moot court is to be taken in the real court. This is the just not training time, but it is to be subsequently reflected in your career. Now today, I would say that two important ingredients have been out of 6 points criteria. Important criteria first, appreciation and application of law to the factum scenario. So in the appellate court, the factum scenario has been nicely placed But in between that time, there was some problem, technical problem, so I couldn't hear the next batch in details. However, nicely presented, factum is presented, and second is application of legal principles and the authorities' law points. See, 1860 IPC is the substantive law, and 1973 CRPC is the procedural law, and both are just if the 1860 is to be taken as the pure science of law jurisprudence, then 1973 the applied science of criminal jurisprudence. Our students have nicely placed the moot court, but the unpleasant part is that the technical problem. But so far the point is concerned, while you are presenting the case under section 3, the case was under section 370, 307 and 397. The common point is hard, grievous hard. I don't find that word or that factum from any argument. So for the mentality point is concerned, very nicely the last speaker held that where is the grievous injury? Prosecution has totally failed to produce that. This is a beautiful placement, and more so, the today's constitutional law day. But I would simply say the poem that in the year 1970s, law day was first celebrated by the Supreme Court Bar Association, and thereafter, subsequently, it has been renamed. It has been nomenclatured as Constitutional Day. But I would say law is much more important. The rule of law devised by Dias, Joint Dias, says that it is the flow continuum. Neither it is born nor it gets dead. And second thing, so far the Constitution is concerned, I would like to name that person who actually drafted the Constitution of India. That is, I would like to refer page 19 of D.D. Bose, Introduction to the Constitution of India, page 19. I would like to refer page 19, and I would like to read the word in verbatim. The draft was prepared by Sri B.N. Rao, R.A.U. Rao, advisor to the Constituent Assembly. A 7-member committee chaired by Sri Sir Alladi Krishnaswamy Iyer was set up to examine the draft. Dr. B.R. Ambedkar, who was Minister of Law from 1847 to 26/1/1950. In this period, the unsung personality who in fact brought Ambedkar in this assembly, he was Yogendranath Mandal from Kumilla, now Bangladesh. Unsung part, I simply reveal, that should be also uttered, otherwise our adoration would be incomplete. And so far, the main point, verb and vibrance of this moot court presented by 2 students, of course, they must have seen the table suggested by teachers. 6 point, that is the main explanation annotative points, which has been आपके लिए आपके शिक्षकों ने जो गोताखोरी कर अनमोल चीज दिए हैं, आपका उसी में शामिल है. So always
Sir, your voice is not audible. I think there is some network issue. I guess he couldn't finish his speech because of the technical issue. We can proceed with the next round for today. That is our parliamentary debate round. For the motion, one nation, one election. And I would like to call upon team 2 from the government side to start with the debate. Do I have team 2 with me? For the parliamentary debate,
Am I audible, ma'am?
yes, Saurav, you're audible. Is the team 2 ready? Saurav and team, are you ready?
Yes, ma'am.
Yeah, ma'am.
Okay, I would like the Prime Minister to start with the speech.
Yeah, ma'am. Yeah. Good afternoon to everyone, respected judges, and the Madam Speaker. Madam Speaker, I, the Prime Minister of this House, going to introduce my resolution for the motion of, and that is, the one nation, one election. Madam Speaker, as I'm speaking, in some corner of the India, some election has been scheduled. Then after model code of conduct will apply. Hence, development program needs to be halted out. So that we need to switch for the one nation, one election in our country. India always in mood of election. If we are really dedicated towards the nation building, towards citizen of India, for the efficient usage of administration and the efficient use of sustainable for the resources, we should go for the motion. Madam Speaker, just I'm quoting one statistics of the spent money in the last Lok Sabha by the Election Commission of India. And you will be shocked to hear that it was some around 3,870 crores. Apart from that, the similar amount of the Home Ministry also spent. Thereupon, some money spent by the Railway Ministry as well. If we calculated all the money, it will go long to 10K crores some around. And the recent publication released by the Center of Media Studies, according to that publication, if we calculated all the spent money for different political party of the India, it will equivalent to 50K crores. It's equivalent to that if we dedicated towards to make aims like hospital in every state, then we can do so. So that is a huge amount. Madam Speaker, if we go for the one election, one nation, one election, then we can cope up with a different problem that are arising due to election of the current setup. As we well aware of the fact that due to current status setup of the political, due to the current political setup, maximum bureaucracy involved in the election process, even though teachers, academicians, and every government employee involved in the election process throughout the year. And the recent Law Commission report, it is also stated the same fact that India should go for the one nation, one election. And I am quoting one of the report of the Justice BP Jeevan Reddy in the 107 report released by the Niti Aayog. The same fact was stated in that report as well, and it was suggested the fourth thing that why India should switch for the one nation, one election. And as per that report, they stresses out on the model code of conduct. As we know that the model code of conduct started from the election date and ended towards the till the election completed out. What's wrong with it? The main issue is that the whole model code of conduct, the ruling party cannot introduce any development schemes, program, and anything that can be work for the citizen of India. And the second issue is the police machinery. As we know that as the election process is going on, we always put it out a lot of the police personnel and engaged with the election process. Hence, we compromising with the security as well. So we should take care of that aspect. If the government introduce the one election, one nation, one election, then through which we can cope up with all the problems that are coming here. And the most important thing that's suggested by that report, that the entire expenditure on actual conduct or election to the Lok Sabha is borne to government of India. And such expenditure or conduct of election with state legislature by the representative state government, when such election are held independently, if the concurrent election to the Lok Sabha and the state assembly is held, then the expenditure is shared between the government of India and the respective state. The initial expenditure is borne by the respective state government, and the summation of the audited report government of India share is reimbursed. So that can be resolved by introducing this setup. Madam Speaker, as we know that the changes always need to inculcate in the every political setup, and now the India become the expensive election of the world, and that is not a proud moment at all. So we should opt this motion, and that's conclude from my side, Madam Speaker.
Okay, Prime Minister, I would request Team 5 for any rebuttal question if you have. Do I have Team 5 with me? Team 5, do I have you all with me? Is there any rebuttal question from your end?
Yes, ma'am.
Go ahead, Aditi.
Ma'am, Speaker, ma'am, I have a question from Prime Minister.
Accepted.
If suppose the Prime Minister says that from 2025, one nation, one election will be started, then till 2022, we have to synchronize all the states. Then in 2022, the government is made. The state has to complete the duration within the 5 years.
Yes, Aditi, are you done with your question? What is your question for the Prime Minister?
Ma'am, my question is that we have the guaranteed of 5 years term to both the elected Lok Sabha and the state assemblies. In our constitution problem, Article 172 and Article 83 deals with the duration of the House of Parliament and guarantee of 5 tenures of both the elected Lok Sabha and the state assemblies.
Right, Prime Minister, do I have you with us? The question has been addressed to you.
Yeah, Madam Speaker. Madam Speaker, we are ready for the amendment problem that the leader of opposition talking about. That we are ready for the amendment to the tenure, and if all the opposition add together, we will succeed the same.
Okay. Now I would like to call upon leader of opposition for your addressing. Leader of opposition, are you prepared? Your voice is not audible. There is some technical glitch. You're not audible.
Am I audible now?
Yes, sir. Yes, you are.
Ma'am, I had a question with respected Prime Minister, sir. Can I ask?
No, you have only one rebuttal question and that has been asked. Now it's...
I, leader of opposition, is one election. The term of the Lok Sabha and that of the state legislative assembly need to be synchronized so that the election to both can be held within a given span of time. For instance, the term of the present Lok Sabha will go up to 2024, but the elections to some of the legislative assembly had already taken place last year, Chhattisgarh, Madhya Pradesh and Rajasthan, and some happened this year, Haryana, Maharashtra and Jharkhand, resulting in different dates of completion of the term. The core issues hinders its implementation in India's parliamentary form of government in which the government is accountable to the lower house, Lok Sabha or Legislative Assembly. It is quite possible that the government can fall before completing its term, and the moment government falls, there has to be election. The election commission sometimes hold elections even one state in many phases. Holding simultaneous elections for whole country has many practical difficulties. Dissolution, it is possible for Lok Sabha to be prematurely dissolved on account of vote of no confidence. It is still uncertain case, and in case of a mid-term election, the term of such a house would only be for the remainder of the tenure, allowing one-time waiver of its anti-defection law in the event of a hung house is another proposal. This is to enable the house to elect a leader. However, these reforms can be adopted even simultaneously elections. The local issues will fade out, hard time to regional parties it will give, delays in election result it will come out. It will also come with constitutional problem which will be needing amendments. Huge population will cause problem because it will be very difficult to administrate. Powerful leaders will manipulate small or common people or poor people, small scale laborers to take the decision, and they will be ruling for regular 5 years. Huge expenditure of government will be taken. National party focuses on wholesome issues as compared to local parties. So issues may be in shadows for the local region. And it is not the biggest problem as compared to water crisis, GDP, currency rate, economic fluctuation, illiteracy, corruption, poverty, pollution, women's safety, education system. So why this? From my side, thank
counter
you.
question for the leader of opposition. Would I permit?
Acknowledged. You can go ahead.
In leader position, it's as far as synchronization is concerned, some straightforward to the leader opposition that to be a opposition, you are ready for the synchronization because totally depend upon you. If you are ready, we can synchronize easily.
We can synchronize, but we can do simple changes rather than changing to one nation, one election. We can change the model of conduct, reduce polling days, club few states together, put a limit, and it became radical after the parliamentary system. At present, one vote machine is being used at every polling station for taking a poll. For holding simultaneous election, the requirement for EVM, VVPATs will double. Every polling station, the election commission has to provide 2 sets, one for legislative and one for Lok Sabha. That will also cost more. There will be also additional requirement for the polling staff, difficulty in transporting materials to the polling stations. There will be also need for security arrangement for simultaneous elections, thus augmenting the central police forces accordingly. The Election Commission of India is already storing EVMs after the election. So how can we double the EVM machines and how we will resolve this question?
Would I answer, Madam Speaker?
Yes, please go ahead.
So talking about the first police personnel, so we don't think so that any more extra police officials is needed for the same, because there is only one polling station and where you have to cast their vote. So there is not an issue. As far as the EVM is concerned, it's a one-time investment. If you are thinking for the future time, you should invest once a time. So that's my answer for your rebuttal.
Okay. I think the rebuttal round is over. Now I would like to call upon Deputy Prime Minister for your speech for the motion.
Ma'am, am I audible?
Yes, you're audible.
Good morning, everyone. Good morning, Madam Speaker. As my Prime Minister has already talked about the same, I am just here by giving some more further arguments that are as follows. As already talked about one nation, one election, it means that voters will cast their vote for electing members of the Lok Sabha and the state assemblies on a single day. That means at the same time or in a phased manner as the case may be. This will make election across the country in such a way that they will be held twice every 5 years. This one nation, one election system will reduce enormous cost involved in separate elections. The one nation, one election would reduce the cost of holding elections and limit all elections to one single season. At present, talking about the present condition in India, election happens somewhere on the other hand almost all the time. And it is often argued that the model code of conduct gets in the way of the government announcing projects or policy plans for the benefits of the people. There is also the view that simultaneous elections would benefit the party that is nationally dominant at the cost of smaller regional players. The system will help ruling party focus on governance instead of constantly in election mode. Polls will boost voter turnout according to the Law Commission. One of the biggest arguments in the favor of simultaneous election is the fact that it would lighten the burden on the government's exchange. If India chooses this system, it will help saving a huge amount of money. The maximum expenditure limit for assemblies is rupees 28 lakhs. This means that if all the states and UTs go for one-time election, then the total cost would be around rupees 11 billion. However, presently around 5 stages go for polls every year. Government, at last, I would like to conclude that government spends a lot of money, time, and energy in the conduct of different elections. That is the reason the government is thinking about one nation, one election in India. Thank you.
I would request the opposition team to pose any rebuttal question if you have for Deputy Prime Minister.
No question.
Opposition team, do you have any rebuttal question for the Deputy Prime Minister?
No question, ma'am. No question. No question, ma'am.
Okay. Now I would like to call Deputy Leader of Opposition for your speech against the motion.
Speaker, ma'am, I Deputy Prime Minister, I opponent Deputy Prime Minister seek the permission of Honorable Speaker. I am against the motion. May I?
Go ahead.
Ma'am, Speaker, ma'am, there are several demerits of one nation and one election. The first one is local issue will fade out. It is observed that election for state assemblies and Lok Sabha and short and distant issue. Regional party target on local issue while national parties target on national issue. So there is a possibility that regional party will not be able to raise the local issue strongly. And the second point is that delay in the election results. At present, when almost all the regional parties are demanding to conduct election to ballot paper, if election are conducted in one time made, then the election results will be declared very late. And there will be the huge requirement of resources. According to the Law Commission, if the country goes to simultaneous election, then the Election Commission has to spend 4,500 crores on the EVM. They will have to double all the EVM machines and requirement of polling staff. The Election Commission have to face many problems related to EVM machines. And we have also the constitution problem also. Article 172 and Article 83 deals with the duration of the House of Parliament and guarantee of 5 years term to both the elected Lok Sabha and state assemblies. And the one more point is that anti-federal consequences. When an election in a state postponed until the synchronized phase, President rule will have to impose in the term period in that state. This will increase the power of President and legislature. And that's all from my side.
The government team, do you have any rebuttal question for the opposition? Deputy Leader of Opposition. Yes, Prime Minister, do you have any question?
Yes, Madam Speaker. Madam Speaker, as the deputy leader position quoted out that if the one nation election will come into the picture, then the regional phases will be compromised. But my answer is simple, that we will not interfering in any particular process of the election. Just we are touching that then one election must be get together in order to save the money, in order to efficient use of the human resources, in order to work for the development of the nation, regard the rest of the unnecessary thing in unnecessary thing. So that's my concern.
Do you have any question for the Deputy Leader of Opposition?
So why you are thinking that we will compromise the faces of the local leader and issues as well?
Can I answer this question, Madam Speaker?
The question has been addressed to the Deputy Leader of Opposition. Deputy Leader of Opposition, are you there with us? Do you want to answer Prime Minister's question for you?
Yes, I have to answer. So, how the Prime Minister says that the money will be controlled, huge machinery and resources will be utilized. I have to answer that when after the 5 years, we have to double all the machinery, all the pooling staff, and many other.
Deputy Leader of Opposition, your voice is not audible. I would request Leader of Opposition to answer on behalf of her if you are available.
As been said by asked by Prime Minister, that how we are concerned that they will be not concerning about the small or regional issues, and as by said by Deputy Leader, she was talking about the money that will be included in doubling the EVM machines and the procedure it will take. And my answer will be to the Prime Minister that the small parties and the local leaders are mainly concerned about the issues related to their specific region, and they will be dealing well with the local people and their problems and situations. As compared to the national issues, national parties mainly focus on their images and worldwide issues on international level, national level, and the major issues, not the small regional issues or any subtopic. That's all.
Okay. So taking this debate further, I would request the opposition whip to come and address the motion.
Yes, Speaker, ma'am. I hereby seek your permission, Madam Speaker, to conclude what they have said by the leaders. One nation, one election idea infringes the concept of responsible government means continuance to the government for the mandate given by the people. People cannot be made to wait for the 5 years until the next election are held. The ruling party at center and state will become insensitive to the people issues if there is only one election in 5 years, and this will result to widespread corruption and maladministration.
Is that all? Opposition whip from your end?
Yes, ma'am.
Okay. Now I would request the government whip to come and conclude the debate session.
Ma'am, I am audible.
Yes, you are.
Can I proceed, Madam Speaker? As Prime Minister and Deputy Prime Minister has already given their arguments for one nation and one election, I am here for the further argument. There are several merits of one nation, one election are as follows. The biggest logic in the favor of the simultaneous election is the saving of government money. If the country goes for one nation, one election, it will save huge money. It is observed that when the election model code of conduct is in force, then the inauguration of new projects does not take place. So one-time election will ensure continuity in policies and programs of the central and state government. We all are aware of that elections are fought with black money, a huge black money turned into white money during elections in the country. So if the elections are conducted throughout the year, then there is a possibility that a parallel economy will grow in the country. One nation, one election will help in smooth functioning of the government machinery. If elections are not conducted annually, then the government need not to move general people through their schemes. That's all. Thank you.
Okay. So I think with this we come to an end of our parliamentary debate round, and the panel of judge for this round would be Shri G.C. Sinha, District Judge, retired of Jharkhand, and Abhishek Prasad, Secretary, District Legal Service Authority, Ranchi. Sir, I would request you all to address the team with a closing remark. Or if you have any input for the team. Sinha, sir.
मेरी आवाज पहुंच रही है?
जी बिल्कुल बिल्कुल आ रही है आपकी आवाज। इस टीम को आपको जो भी बोलना है, कोई टिप देना है तो आप प्लीज दे दीजिए।
It's good to see the youth of the nation come with creative ideas and such good argument, and I look forward to seeing better performance in future.
Thank you so much, sir. If we have Abhishek Prasad ji. Okay. Okay, moving on to the next event for today. सर आप म्यूट कर लेंगे अपना ऑडियो, बहुत ज्यादा आवाज आ रहा है उधर से। जी सिन्हा सर। Thank you so much, sir. Moving on to the next event for today, we have got Nukkad Natak by Mansi and team. And before we play the video, I would request Mansi to come up and tell us or give a brief idea about why she chose this particular topic for the Natak.
Good morning, everyone. The drama that we have performed here is a short brief about what is Constitutional Day and why it is celebrated. We have also tried to show the 6 fundamental rights that our Constitution has guaranteed us, that is, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedy. Please have a look at our drama.
Mansi, your voice is not audible.
Ma'am, please. Ma'am, I have.
Are you done?
Ma'am, may I repeat that again? Yes.
Just repeat the last line.
Please have a look at our drama and enjoy it. Thank you.
Thank you so much, Mansi. I would like to request the technical team to play the drama. And I think because there is some technical issue, we have to wait for 1 minute, I think. Okay. It's here.
क्या आज 15 अगस्त है या 26 जनवरी? नहीं, ना ही आज 15 अगस्त ना ही 26 जनवरी, पर क्यों? वो देखो ये लोग आज के दिन तिरंगा लेकर क्यों घूम रहे हैं? चलो उनसे जाकर पूछ के आते हैं। अच्छा, आज क्या है?
आज संविधान का दिवस है। आज के इस दिन की वजह से हम आज स्वतंत्र हैं और स्वतंत्र तरीके से अपने दैनिक जीवन के फैसले ले पाते हैं। संविधान का दिन आज हमारे संविधान को 71 वर्ष पूरे हो चुके हैं। 71 वर्ष पहले आज ही के दिन हमारा संविधान बनकर तैयार हुआ था, जिसकी वजह से हमें कई सारे मौलिक अधिकार प्राप्त हुए थे। आज संविधान का जन्मदिन है, आओ मिलकर मनाते हैं ये विशेष दिन।
ये मौलिक अधिकार क्या होता है?
मौलिक अधिकार वो होते हैं जो हमें मौलिकता प्रदान करते हैं संविधान के द्वारा, और जिससे राज्य भी हस्तक्षेप नहीं कर सकता।
अच्छा, आओ मिलकर बनाते हैं ये दिन।
पापा,
हाँ बेटा बोलो।
मुझे कॉलेज ट्रिप के लिए गोवा जाना है, क्या मैं जाऊँ?
नहीं बेटा, आप घर के अंदर जाओ।
पापा मुझे भी कॉलेज की तरफ से गोवा ट्रिप में जाना है, क्या मैं जाऊँ?
हाँ बेटा बिल्कुल जाओ, और ये कुछ पैसे रख लो, काम आएंगे।
थैंक यू पापा।
ठीक है बेटा।
पापा अपने भैया को जाने दिया, मुझे नहीं जाने दिया, ये क्या है?
इस पात्र से आप समझ सकते हैं कि हमें मौलिक अधिकार समानता जो अनुच्छेद 14 में दी गई है, इस पात्र में मौलिक अधिकार समानता नहीं दी गई है, लेकिन हमें मौलिक अधिकार समानता की अधिकार है।
आज रोड देखे थे, वहाँ कितना ज्यादा खराब था ना, महिलाओं को सुरक्षा है कुछ? हम तो ना घर पे सुरक्षित है ना बाहर। बेरोजगारी कितनी है?
सच में बेरोजगार लोग तो आजकल जगह जगह पे मिलते हैं। रुक जाइए, क्या कर रहे हैं? हमारी सरकार बहुत अच्छी है, समझे?
बिल्कुल अच्छी नहीं,
आप सरकार के आप कुछ नहीं बोल सकते, आपका कोई अधिकार नहीं है, आपका कोई अधिकार नहीं है सरकार को कुछ भी बोलने का।
कुछ नहीं करती है।
अभिव्यक्ति की स्वतंत्रता की आजादी दी गई है, जो कि अनुच्छेद 19 में है।
क्या खाया जाए?
चाय और पकौड़े?
2 चाय 1 पकौड़ी।
यार मुझे कोई याद नहीं रहा।
मालिक कहाँ है?
क्या हो नाम?
हमने तभी से ऑर्डर किया, कोई लाया ही नहीं है।
रानी,
तुम यहाँ क्या कर रही हो? तुम्हें काम करने के रखे हैं, पढ़ने के रखे हैं? वहाँ देखो ग्राहक बैठे हुए हैं, उन्हें इंतजार हो रहा है, जाओ निकल उनका काम करो। वो क्या करता है? नमस्ते। आप ऐसे करें?
ये हमारे घर में आप ऐसे कीजिए।
ये है हमारा घर, सबसे अच्छा है हमारा घर।
अल्लाह के बच्चे,
हम भगवान के बच्चे हैं।
आप लोग रुक जाइए, क्या कर रहे हैं? गॉड इज एवरीवेयर, हम लोग सब गॉड के बच्चे हैं।
हम तो भगवान के बच्चे हैं,
अल्लाह के बच्चे, अल्लाह का नाम लो। हम सब वाहिगुरु के बच्चे हैं, हम लोग सब एक हैं। हमारा कोई धर्म और जात पात नहीं है, हमारा बस एक ही धर्म है कि हम भारतीय हैं। वंदे मातरम।
पापा देखिए, मेरा 12th का रिजल्ट आ गया। पापा मुझे 96% आया, अब मुझे कॉलेज में एडमिशन मिल जाएगा।
बेटा अब तुम्हें जितनी पढ़नी थी वो तुम काफी पढ़ चुकी हो।
पापा ऐसा क्यों?
अब तुम्हारी शादी की उम्र हो गई है बेटा।
नहीं पापा, पर मुझे पढ़ना है।
नहीं बेटा, अब तुम्हें जितना पढ़ना था वो तुम काफी पढ़ चुकी, अब तुम्हारी शादी की उम्र हो गई है।
ऐसा क्यों? क्या मैं जब चलना नहीं आता तो सड़क पे क्यों चलते हो?
ओह मंदी है ना, तो दिखता नहीं है।
जब देख नहीं सकते तो घर पे रहा करो, रोड सड़क पे मत निकला करो।
Okay, so that was Nukkad Natak by Mansi and team. Some great issues picked up by her. Great work, Mansi and the team. Now I would like to move on to the next event, which is a message by certain students on constitutional law. I would request the technical team to play the video.
As you all can see in the poster, I want to describe the right to equality rights that we all are enjoying. It is given in the Article 14 of Constitution of India provides for equality before law or equal protection of laws within the territory of India. It states the state shall not deny to any person equality before the law or the equal protection of laws within
Because of some technical issue, the video is not playing.
Opportunity in matters of public employment, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Thank you.
The next video is by Fatma Jannat, BBA LLB 2018 batch on fundamental rights. I would request the technical team to play the video by Fatma Jannat.
To one and all present here, myself Fatma Jannat, BBA LLB semester 5, got a golden opportunity on the specious day of Constitutional Day, which is celebrated on 26th November and adopted by Constitution Assembly on 26th November 1949 and came into force on 26th January 1950, where Dr. B.R. Ambedkar was the first Minister of Law and Justice, which there are the fundamental rights. That there are number 1 is equality, right to equality, number 2, right to freedom, number 3, right against exploitation, number 4, the right to freedom of religion, number 5, culture and educational right, number 6, right to constitutional remedy. Now I would like to explain the right to equality, which is first. In our Constitution, Article 14 to 18 includes equality before the law, the prohibition of discrimination on ground of religion, race, caste, sexual gender and gender undefined, place of birth, gender of opportunity, equality, opportunity in matters of employment, the abrogation of untouchability and abrogation of titles. Next, number 2 is right to freedom, which in our Constitution Article 19 to 22 includes freedom of speech and expression, assembly, association or union or cooperative movement, residence and right to practice any profession or occupation. Next is number 3, right against exploitation, which tells us, reveal us from tools, we want to go school, where it prohibits all forms of forced labor, child labor and trafficking of human beings. Children under age of 14 are not allowed at work. Next, number 4, the right to freedom of religion comes in Article 25th to 28th of Constitution, includes freedom of conscience and free profession, practice and prohibition of religious freedom to manage religious affairs, freedom to from certain taxes and freedom from religious instructions in certain educational institutions. Next came the cultural and educational right. The education is our right, not our privilege. Comes the privilege, the rights of any sections of citizens to conserve their cultural language or spirit and right of minority to establish and administer their educational institution of their choice. Next, last is right to constitutional remedy. In our Constitution, Article 32 says about it became an indissoluble part of our fundamental right as it assures the actual dissipation of justice on contempt of our basic rights. Now, the fundamental duties of a citizen were added to the Constitution by the 42nd Amendment in 1976. That is, to abide by the Constitution and respect its idol and institution, the national flag and national anthem. Next, to cherish and follow the noble ideals which inspire our national struggle from freedom. Next, to uphold and protect the sovereignty, unity and integrity of India. Next, to defend the country and retain national service when called upon to do so. Next, to value and preserve the rich heritage of our composite culture. Next, to safeguard the public property and to abjure the violence. Now, I would like to state the preamble of our Constitution of India, 1950. We, the people of India, having sovereignly resolved to constitute India into sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unit and integrity of nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and to give ourselves this Constitution. This concludes my poster, and thank you so much.
Very innovative, Fatma. That was indeed a great message for everyone. Next message is by Ayushi Raj, BBA LLB, batch 2020 on rights against exploitation. I would request the team to play the video by Ayushi Raj.
Hello everyone, this is Ayushi Raj from BBA LLB program. Today, I am present in front of you all to tell about my poster which is based on the topic fundamental rights. There are 6 basic fundamental rights present in our constitution. Right against exploitation is one of the basic rights given to us, that is human beings. In my poster, I have tried my best to show the pain of a child who is being sold for money. But may I ask you something? That is a human being a commodity to be sold or purchased? I think the answer is no. Similarly, in my poster, I have tried to show that how children of a young age are forced to do work. These works not only affect their mind but also their physical health. Children who are the future of our country are doing these kinds of work. I don't think it's right. Similarly, in our society, there is gender discrimination, where work for both women and men are equal, but not the wages. Why? These all are the questions which arises in all of us our mind. At last but not the least, I like to tell you that we all should stop this and try our best to make our country a better place to live in. Thank you.
Thank you so much, Ayushi, for your message. With this, we come to an end of events. And before we move on to the voice of thanks, I would like to appreciate all the students who were there actively participating. Saurav, Mansi, Siddharth, Aditi, everyone. You all did a great job. And thank you for making this program a successful event. Moving on to the next round, I would like Alok sir, Assistant Professor of ICFA University, Jharkhand, Faculty of Law, to give a voice of thanks and also announce the winners for today's round. Over to you, sir. Yes, sir.
Okay, it is very difficult always to announce the winner.
Nice.
Thank you all. It is always very difficult to announce the winner because every participant has to be prepared very well. And since we have a new law school, so it is also so many difficulties to the participant for preparing the moot court and the parliamentary debate kind of things of the event. But I understand all these limitations, and in spite of all these limitations, the team participating in a semi-final rounds, in primary rounds, and in this final round will have to make a very best effort. And for that, all teams are really we feel proud that you will have to participate and as well as to make this event success. Now, coming to the formalities and announcement of the winner, and for parliamentary debate, the panel of judges will decide the winner, team 05. That is the team of Siddharth, and the best speaker of parliamentary debate is to be adjudged Saurabh Bhardwaj. BBLLB 2019. Now coming to the moot court winner, moot court winner, team 12, presenting for appellant side is to be adjudged winner. The team is for Hojifa, Fatma, and Astha, and the best speaker of the moot court is Hojifa, LLB 2018. Now, coming to the poster presentation and with narration in respect of the masses of fundamental right, the winner is Fatma Jannat, BBLLB 2018 batch. So this is all about the winner. I congratulate firstly to all team who is participating, and then winner. And I hope in future we will have to improve certainly the skills which is required to be present here. Now, I thankful to all guest participant of this event. I thankful especially to all the universities authority who are cooperating us to make this event virtual. And I thankful to the registrar sir, vice chancellor sir to address and grace this occasion. I thankful to GC Sinha sir. I thankful to Pati Bhattacharya sir. I thanks to DLSA for supporting this event, because this event is supported by District Legal Service Authority Ranchi. Now, I hope we will have to be organize this kind of student oriented event in future. And at last, I just say it is a day, this is a day for reminding us to preserve, protect our constitutional values so that to uphold rule of law and democracy in our country. Thank you all. Thank you.
Okay. I would like to thank the technical team for the support. Amarjit sir for constantly being there as a help, and Alok sir who was there for us to guide us. And last but not the least, our students who have done a great job. So we are actually proud of you. Next, I would request all of you to switch on your video for the group photography with the participants and students and everyone present here. Kindly switch on your video so that the technical team can take a snap of this event. Sir, kindly let us know when the photography is done. Okay, moving on to the last session. I would request the technical team to play the national anthem, and I would request everyone to kindly rise for the anthem.
जनगणमन अधिनायक
Thank you, everyone. With this, we come to an end for today's celebration. Thank you for participating and thank you for attending. Have a good day, everyone.
Thank you, ma'am.
Thank you, ma'am. Thank you, sir.
Thank you, ma'am.